My gentle grandfather was buried with no family present and no explanation given. I spent years uncovering the story of his last days, and what I found still makes me grieve twice over. The funeral home director looked at me across his desk with the expression of a man who had delivered difficult information many times and had developed a technique for it, which was to keep his face neutral and let the words do the work without the face adding anything extra. He said, "Your grandfather was interred 6 weeks ago." He said, "The arrangements were made by a third party with legal authority over the estate." He said, "I understand this may be unexpected. I was 34 years old and I had driven 4 hours to get to this funeral home in a mid-sized Ohio city where my grandfather had lived alone for the last 8 years of his life. And I had driven those 4 hours because 3 days earlier I had called to wish him a happy birthday, and the number was disconnected, and when I called my Uncle Desmond, who lived 40 minutes from my grandfather and was the family member, I had always understood to be in closest contact with him," Desmond had said, in a tone that was not precisely guilty, but that contained within it the acoustic texture of something being managed. "I should have called you." That tone. Those 6 words. I had felt them in my chest before my brain had fully assembled them into meaning. I said to the funeral home director, "Who was the third party?" He said, "A man named Desmond Quay, my grandfather's son, my uncle, my father's brother, the man who should have called me." I put both hands flat on the funeral home director's desk and kept them there because they needed to be somewhere that was solid. I had been visiting my grandfather, Kofi Asante Quay, for as long as I could remember. He was my mother's father-in-law. She had married my father, his eldest son Nana. And when my parents divorced when I was 11, the relationship that survived most intact was the one between me and the old man. My father had his complications, and my mother had hers. But Grandfather Kofi had none that I could see. He was 78 when I drove to the funeral home, and he had died at 77, which meant he had died 6 weeks before his own 78th birthday. Which was the birthday I had called to wish him, and instead found a disconnected line and then found Desmond, and then found myself driving 4 hours to Ohio with a cold in my chest that had nothing to do with the November weather. Kofi Asante Quay had been a civil engineer for 30 years, and had retired to the Ohio house when my grandmother died, and had made himself a quiet life there. Garden, church, the library 3 times a week, a particular brand of Ghanaian hot sauce he ordered online and used on everything. He was a man of small, precise pleasures and large, quiet warmth, the kind of grandfather who remembered the specific details of your life, your job title, your neighbor's name, the book you mentioned reading 6 months ago, and who asked about them at every contact, which was monthly by phone and 3 or 4 times a year in person. He was the most consistently present adult in my childhood and my adult life, and I had not been at his funeral. Nobody who loved him had been at his funeral. 6 weeks had passed, and I was the first person to walk into this funeral home and ask about him, and I was going to need to understand why. Desmond Quay was 51 years old, 8 years younger than my father, and I had never spent significant time with him because he and my father had a relationship that could be described as periodic and fraught, which is the polite version of what I observed growing up. He had moved to Ohio about 8 years before Grandfather Kofi, which was how he came to be the closest family member geographically. A coincidence of location that had been, I was beginning to understand, leveraged into something else entirely. I knew, in the general way of family knowledge that circulates without being specifically examined, that Desmond had had financial difficulties over the years. I knew that he had borrowed money from Grandfather Kofi at least twice, because Grandfather had mentioned it in the way he mentioned family complications. Accurately, without drama, in a tone that made clear he was informing rather than complaining. I had not paid close enough attention to these mentions. This is one of the things I have to live with, that the information was available to me, and I had processed it as background rather than foreground. I had categorized my grandfather's mentions of Desmond's debts under ordinary family complexity and had not looked more closely at what was happening. The funeral home director had given me what he was legally authorized to give, which was the name of the arranger and the date of interment. For everything else, I was going to need to work. The first official I spoke to was a woman named Audra Flemons, an elder law attorney with 19 years of practice, whose office was in Columbus and who had been referred to me by a colleague of mine at the accounting firm where I worked. I was a certified fraud examiner, which is relevant because the skills I use professionally to identify financial irregularities are the same skills I was about to need personally. Audra met with me 4 days after the funeral home visit. On in an office with clean lines and a large window, and the particular organized energy of someone who had developed over 2 decades the ability to hear the worst things families did to each other without being visibly destabilized by them. I told her everything I knew. She listened the entire way through, and then asked 12 very specific questions, 7 of which I could not answer, which told me how much I still didn't know. She said, "The key questions are when the power of attorney was established, what it covered, and whether your grandfather had cognitive capacity when he signed it." She said, "If it was signed while he had capacity and he subsequently lost capacity, the arrangement may be legal even if it was not what he would have chosen." She said, "If it was signed when he already lacked capacity, you potentially have grounds for challenge." She said, "Either way, I want to see the document." I told her I would get it. I didn't yet know how, but I told her I would get it. My father, Nanakwe, was 63 years old and lived in Atlanta and had a relationship with his own grief about his father that was complicated in ways I had always sensed and never fully understood. When I called him the day after the funeral home visit to tell him that his father had been buried 6 weeks ago without his knowledge, he was quiet for a long time. The quiet was not the quiet of someone who didn't know. It had a different texture. I said, "Dad, did you know?" He said, "I knew he was sick." I said, "How sick?" He said, "Desmond told me he had dementia. He said it was bad." He said, "I should have come." He said this with the weight of a man applying that sentence to a much longer period than the last 6 weeks, and I heard it that way, and I let it sit without responding to it because there was too much in it to address at once, and because I needed information more than I needed a reckoning with my father's choices right now. I said, "When did you last speak to grandfather directly?" He said, "Maybe a year ago, maybe 14 months. He said it the way you say something you are ashamed of." I said, "He called me every month." He said, "I know." He said, "You were always better at it than I was." I said, "Dad, I need everything you know about Desmond and grandfather's finances." He was quiet again. Then he said, "I can tell you what I know. I'm not sure it's enough. It turned out to be more than enough to start. What my father told me, and across 2 long phone calls over the following week, was this. Grandfather Kofi had owned the Ohio house outright, no mortgage, purchased in full from his retirement savings. The house was valued, as of the most recent county records, at approximately $340,000. He had additional savings of an amount my father estimated at somewhere between $80,000 and $120,000, based on conversations with grandfather over the years. Desmond had borrowed $22,000 from grandfather in 2018 and $15,000 in 2020, neither sum repaid as of the last time my father had discussed it with grandfather, which was in that phone call approximately 14 months ago. Grandfather had mentioned to my father during that call that Desmond was helping him with his affairs, that there were some documents to sign, and that he trusted Desmond to manage things. My father had not asked what documents. He had not asked what managing things meant. He had filed it under the same category I had been filing grandfather's mentions of Desmond's debts. Ordinary family complexity, background, not foreground. We had both been wrong about which category it belonged to. I drove to Ohio for the second time 3 weeks after the funeral home visit, this time with a specific agenda. I went to the county probate court. I went to the county recorder's office. I am a certified fraud examiner, and I know where financial documents live, and I know how to read them. And what I found across 1 full day of working through public records was the following. A property deed transfer, recorded 4 months before my grandfather's death, transferring ownership of the Ohio house from Kofi Asante K to Desmond K. Then a notarized power of attorney document, recorded approximately 10 months before my grandfather's death, granting Desmond broad authority over Kofi's financial and medical affairs. A bank account change of signatory, recorded approximately the same week as the power of attorney. I sat in the county recorder's office with these documents in front of me, and I did the arithmetic that certified fraud examiners do, which is to line up the timeline against the known facts, and the lineup was damning in the specific way of things that have been carefully arranged to appear legitimate, and that reveal their illegitimacy only when you look at all of them together. The power of attorney was signed 10 months before death. My grandfather had been diagnosed with dementia. I had found the diagnosis in a brief medical record mention 14 months before death, which meant the power of attorney had been signed 4 months after a dementia diagnosis, which meant the question Audra Flemons had asked, did he have cognitive capacity when he signed it, was exactly the right question. I called Audra from the parking lot of the county recorder's office. I photographed every document and emailed them to her while we were still on the phone. She said, after a silence while she read, "This is what I was looking for." She said, "The timing is significant." She said, "A dementia diagnosis 4 months before signing a power of attorney granting broad financial authority, combined with a property transfer within that same period, is a pattern I've seen before in elder financial abuse cases." She said, "I want you to get his medical records. I want to see what his treating physician documented about his cognitive status at the time of signing." She said, "And I want you to find out whether an attorney was involved in the preparation of the power of attorney document or whether Desmond prepared it himself." I looked at the document. The notary information was there. The attorney line was blank. No attorney had prepared it. My grandfather had signed a power of attorney drafted by his son, granting that son control over his entire estate 4 months after a dementia diagnosis, and no independent attorney had reviewed it or witnessed it or assessed whether Kofi Asante understood what he was signing. I sat in the parking lot and thought about my grandfather ordering Ghanaian hot sauce online and going to the library 3 times a week and remembering the specific details of my life in every phone call. And I thought about who he had been when I knew him. And I thought about what 4 months of dementia progression does to a man's ability to understand a legal document presented to him by a son he trusted. And my hands were doing the thing they had been doing for 3 weeks, which was to be unsteady when I was sitting still and steady when I was doing something with them. So I picked up my phone and started making the calls that needed to be made. The second official who entered the story was Detective Sergeant Amatowia, 14 years in the Financial Crimes Unit of the Columbus Metropolitan Police Department, who was assigned to the case after Audra Flemons filed a formal complaint with the Elder Abuse Hotline, and the complaint was escalated based on the documentation. Detective Tawia had the quality of someone who took methodical work seriously and was unimpressed by complexity because she had seen its entire range. She met with me and Audra in Audra's office and spent an hour and a half asking questions that covered the same territory as Audra's initial questions and several territories Audra had not covered, including whether there were other assets I was unaware of, whether grandfather had received any Medicare or Medicaid payments in his last months that might connect to additional financial streams, and whether Desmond had any associates who might have been involved in drafting or executing the documents. I answered everything I could answer. She made notes in a way that suggested she was building something, assembling a structure from the materials I was providing, and that the structure had a shape she already partially recognized from other cases. She said she would need to subpoena financial records. She said this would take time. I told her I had been finding, over the preceding weeks, that everything took more time than the urgency of the situation seemed to warrant, and she said, "That's accurate." And then she said, with the directness of someone offering information because it was more useful than comfort, "The documentation you've assembled is stronger than most of what comes to us at this stage." I told her it was my job to document things. She said, "Keep doing it." The third official was a geriatric specialist named Dr. Emmeline Osei Boateng, 26 years in geriatric medicine, who had been grandfather Kofi's treating physician for the last 2 years of his life, and who agreed, through Audra's formal request and my status as an interested party in the probate challenge, to provide a clinical assessment of his documented cognitive state at the time of the power of attorney signing. This required a court order, which Audra obtained, and the medical records, which the court order produced, and Dr. Osei Boateng's written assessment, which arrived 6 weeks after I first contacted Audra and which I read in my car in the parking lot of my own office at 7:30 in the morning because that was when Audra emailed it to me and I could not wait until I was inside. The assessment confirmed what the timeline had suggested. At the time of the power of attorney signing, 4 months after diagnosis, my grandfather's documented cognitive status indicated moderate impairment in executive function and short-term memory, with preserved long-term memory and social function. Dr. Osei Boateng's professional assessment was that, in her clinical judgment, a patient with this documented cognitive profile was unlikely to have had full understanding of the legal implications of a broad power of attorney document, particularly in the absence of independent legal counsel. She used the phrase unlikely to have had full understanding 4 times in the document, which is the language of clinical precision rather than certainty, and it was enough. The crisis that I had been building toward arrived not as a dramatic confrontation, but as a phone call from Audra on a Thursday morning, 3 months after I first walked into the probate court. She said, "Desmond has listed the house." I said, "He's selling it?" She said, "It's on the market as of this morning. $325,000, price to move quickly." She said, "If we don't get a court order today preventing the sale, he can complete a transaction in days." She said, "I need you to authorize me to file an emergency motion, and I need you to be available this afternoon because we may need you in front of a judge." I said yes to everything before she finished the sentences. The next 8 hours were the specific kind of chaos that legal emergencies produce. Documents assembled and filed and reviewed, phone calls between Audra and the probate court. Need a call from Detective Tawaya, who had been monitoring developments and whose subpoenaed bank records had arrived 2 days earlier and who had information that strengthened our position considerably. The information was this: Grandfather Kofi's bank account, which Desmond had gained signature authority over via the power of attorney, had been drawn down by $62,000 over the 14 months between the power of attorney signing and grandfather's death. $62,000. Withdrawn in amounts between $1,500 and $4,000, frequently enough that the pattern was clear and the total was what it was. Detective Tawia said, "This is the pattern." She said it in the tone of someone confirming something they expected to find and are not surprised by and are also not satisfied by. Now, which is the specific tone of someone who has seen too many variations of this pattern to find the confirmation of another one anything other than sad? I filed the documents with Audra. The emergency motion was heard that afternoon. The judge who heard the motion was the Honorable Bertram Asante, no relation to my family, despite the name, which was a coincidence I noted and moved past, who read the motion and the supporting documentation in approximately 20 minutes and asked Audra 2 questions and then granted the temporary restraining order preventing the sale of the property pending resolution of the probate challenge. Audra called me from the courthouse steps while I was sitting in my car outside my office. She said, "It's done. The house can't be sold." After I let out a breath that I had been holding in various configurations for 3 months, and my hands did the thing where they were unsteady when I wasn't using them. Audra said, "This is not the end of the process. This is the beginning of the resolution." I said I understood the difference. She said, "There will be a full probate hearing. Desmond will be represented. The challenge to the power of attorney will be contested. This will take time." I said, "How much time?" She said, 8 months to a year, depending on the court calendar and how aggressively he defends. I said, "He'll defend aggressively." She said, "Most likely." I said, "Good." I wanted a word for what I was feeling that was more precise than anger. Why? Because anger was the top layer and underneath it was something more specific. The specific fury of watching a person who should have protected a gentle old man instead dismantle everything that old man had built, and wanting the full accounting, not just the preservation order but the complete record, the official version, everything named and numbered and entered into a document that could not be quietly managed away. The full probate hearing was 8 months later. I was present. My father was present, which required a conversation between us that was long and difficult, and that covered territory we had been avoiding for years. His relationship with his father, the distance he had kept, the ways guilt and grief had organized themselves in him over the preceding decade. He came. That mattered. My Aunt Beatrice, my grandfather's sister who lived in Toronto and who I had contacted as part of my research, and who had her own account of the last 18 months of grandfather's life that added significant texture to the official record, provided a written statement because she could not travel. Her statement contained a detail that I had not known. She had called Grandfather Kofi 9 months before his death, and he had said, during the call, that he was confused about something Desmond had asked him to sign and that he wanted to ask her about it but couldn't remember what it was. She had noted the confusion and had meant to follow up and had not followed up because life had intervened and because she had told herself it was probably nothing. She wrote in her statement, "I will carry that failure for the rest of my life." And I understood the sentence in a way that was both specific and general. Specific to her and general to everyone who had been close to Kofi Asante Kwe and had not been paying close enough attention during the window when attention might have changed things. Desmond had representation. An attorney named Kevin Fairweather, who was competent and professional and who made the arguments that were available to him, which were the arguments of technical compliance. The power of attorney was properly notarized. The property transfer was recorded. The arrangements were made by a legally authorized party. Audra countered with the capacity evidence, Dr. Oze Boateng's assessment, the financial records showing the $62,000 drawdown, the timeline that placed the power of attorney signing 4 months into a dementia progression, and the absence of independent legal counsel at any point in the process. The judge, a woman named the Honorable Constance Abari, who had been on the probate bench for 12 years, read everything carefully and asked questions that suggested she was assembling the same structure I had been building for 8 months. She took the case under advisement for 3 weeks. Her ruling ran to 11 pages. I read all of them. The core findings were the power of attorney had been obtained at a time when the testator's documented cognitive impairment was sufficient to raise serious questions about capacity. The financial activity during the period of the power of attorney was inconsistent with the testator's known financial behavior and constituted probable undue influence. The property transfer was voided. The estate was ordered to be administered according to my grandfather's prior written will, which predated the power of attorney by 4 years, and which divided his estate equally between his 2 sons and contained specific provisions for his grandchildren. Desmond was ordered to repay the estate $62,000. Detective Tawia's fraud case was ongoing and independent of the probate ruling, but the probate findings were entered into her case record, and she had called me the morning before the ruling to say she was confident the evidence supported criminal charges. Desmond was charged 6 weeks after the probate ruling with elder financial abuse and exploitation of a vulnerable adult. He entered a plea that I am not going to detail here because the specific terms of plea agreements are less important to me than the fact of the record. He's the official, documented, unretractable record that states what happened to my grandfather in the last 14 months of his life. He lost his ability to benefit from a crime he had spent years setting up. He lost his professional license. He had been working as a financial advisor, which is its own particular irony. His wife filed for divorce 4 months after the charges, which I mention not because I take satisfaction in other people's marital failures, but because it is part of the complete accounting, and I am committed to the complete accounting. The house was sold as part of the estate administration, and the proceeds were distributed according to the valid will. My share came to approximately $42,000. I donated it to an elder abuse prevention organization in my grandfather's name. However, it was not a gesture of rejection. I needed to do something with it that honored who he was, rather than simply adding it to my own account. And he was a man who had spent his working life building things that outlasted him, and I wanted the money to do the same. I visited his grave for the first time 6 months after the probate ruling, which was also the first time I had been to the cemetery because he had been buried without us, and I had needed the legal process to complete before I could stand at the grave without the incompleteness of it overwhelming everything else. My father came with me, which was his own form of accounting. The headstone had been placed by Desmond, which meant it had no flowers and minimal inscription, just name and dates, nothing more. I brought flowers. I brought a photograph of Grandfather Kofi from 1994, I'd taken at my 10th birthday, which is the earliest photograph I have of him, where the expression on his face is the expression I remember most. Attentive, warm, specifically interested in whoever he was looking at, which in the photograph was me. I had the photograph laminated. I put it at the base of the headstone under the flowers. My father stood beside me and did not speak for a long time, and then said, "He deserved better." He said it to the headstone, not to me. I said, "Yes, he did." We stood there together for a while, 2 people who had both failed to pay attention during the window when attention could have made a difference, and who were both going to have to carry that alongside the grief and the resolution and everything else. That is the accurate account. The resolution was real, the justice was real. And underneath both of them, steady and permanent, is the grief of what was taken from a gentle old man in the last months of his life by someone who was supposed to love him, and the grief of not having been at his burial, and the grief of standing at a grave with flowers too late, and those griefs do not resolve. They become part of what you carry. He deserved better. That is the only sentence that matters. It will always be true.